Mr. Portman, Mr. Reed, Mr. Risch, Mr. Roberts, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Sass, Mr. Schatz, Mr. Schumer, Mr. Scott, Mrs. Shaheen, Mr. Shelby, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Udall, Mr. Van Hollen, Mr. Warner, Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young, Senators voting in the affirmative: Alexander, Barrasso, Blunt, Bozeman, Burr, Capito, Cassidy, Collins, Corker, Cornyn, Cotton, Crapo, Cruz, Daines, Enzi, Ernst, Fisher, Flake, Gardner, Graham, Grassley, Hatch, Heller, Hoeven, Heidt-Smith, Inhofe, Isaacson, Kennedy, Kyle, Lankford, McConnell, Moran, Paul, Perdue, Portman, Risch, Roberts, Rounds, Rubio, Sass, Scott, Shelby, Sullivan, Thune, Tillis, Toomey, Wicker, and Young. Mr. Manchin, aye. Senators voting in the negative: Baldwin, Bennett, Booker, Brown, Cantwell, Cardin, Casey, Coons, Cortez Masto, Duckworth, Durbin, Feinstein, Gillibrand, Harris, Heinrich, Kane, Klobuchar, Leahy, Markey, Merkley, Murkowski, Murphy, Murray, Nelson, Peters, Schatz, Smith, Stabenow, Tester, Udall, Warner, Warren, Whitehouse, and Wyden. Mr. Sanders, no. Mr. Lee, aye. Ms. Hassan, no. Mr. Jones, no. Mr. Johnson, aye. Mr. Schumer, no. Mr. Donnelly, no. Ms. Heitkamp, no. Mrs. McCaskill, no. Mr. Menendez, no. Mr. Reed, no. Mr. King, no. Mr. Van Hollen, no. Ms. Hirono, no. Mr. Blumenthal, no. Mrs. Shaheen, no. Mr. Carper.
Senator is not recorded.
I vote no.
Mr. Carper, no.
Are there any senators in the chamber who wish to change their vote? As a reminder to our guests in the galleries, expressions of approval or disapproval are not permitted in the Senate galleries. On this vote, the yeas are 51, the noes are 49. The motion is agreed to.
on here. You gotta bring them this way. Keep moving, guys.
made that the person making that allegation actually has to come forward with some evidence. A number of senators, actually it was a bipartisan consensus, wanted the FBI to conduct a limited investigation into current credible allegations that were pending. They wanted the FBI to interview individuals like Mark Judge, who had already offered a sworn statement under penalty of felony, and others who may have had information that were identified by Dr. Ford as being present on the day that this alleged activity took place. There was no confirmation, there was no corroboration. In fact, there was a refutation. The people she said were there and could be witnesses, were witnesses to what happened, said, I have no knowledge of that. Dr. Ford's best friend, Leland Kaiser, said, I don't even know Brett Kavanaugh. I've never met him. Well, we've all had an opportunity to read the confidential report. We've seen who was interviewed, what they were asked, and any doubts that people may have had should now have been put to rest by what the contents reveal. These fantasies about Judge Kavanaugh being some sort of serial high school or college predator have been exposed as only that, myths, not based on fact. There's no reliable evidence whatsoever to support any of these baseless allegations against Judge Kavanaugh. But as we know, this wasn't exactly designed to be a truth-finding process. This wasn't a search for the truth. Our colleagues across the aisle had already made up their mind a long time ago, some even before Judge Kavanaugh had been nominated. This was more of a, as the majority leader said earlier today, not a search for the truth, but a search and destroy mission. And obviously, as they continue to move the goalposts, calling for more delays, more investigations, there's been 7 background investigations by the FBI of Judge Kavanaugh during his public service. The FBI has talked to more than 150 witnesses. Don't you think if there were anything to these outrageous allegations that some of that would have come up at some point in the 7 FBI background investigations that have been conducted?
Good job, y'all. Thank you.
Down the hallway. I'm not going to tell you again. All the way on the other side of the restroom. Because it's too close to officers whose hands are on prisoners and they can't defend themselves. Okay?
They're not prisoners, they're protesters.
This door right here, okay, just, okay. Also living room, okay. Living room so other people can walk through, please. Open up so other people can walk through.
It's blocked off right now. You're going to the stairs, just go back down there. It's blocked off, protests and stuff like that, so we think it's blocked off. I don't know where it goes. Sure, if you go back down, back down. situation going on.
And at that time, the Democratic ranking member and chairman agreed with him. We provided all the information requested, as we should. In this case, with Republican control of the committee, we were limited. We've been denied access to an entire 35-month period in Judge Kavanaugh's White House career when he worked as one of the president's closest advisors, the White House staff secretary. He worked during that time on controversial issues like same-sex marriage, abortion, torture, and executive power. It's unlikely that there are documents in Kavanaugh's, it's likely that there are documents in Kavanaugh's staff secretary record that would impact how senators would vote on his nomination, and that's why they were hidden. There's also an unprecedented partisan effort to screen and limit the documents that the committee itself could see. I listened as the senator from Texas said, well, Dr. Ford had a partisan lawyer. Guess who screened the documents that were going to go from the official records to our Judiciary Committee to review for that nomination of Brett Kavanaugh? The man's name was Bill Burke. Bill Burke, by every measure, is a partisan lawyer. I guess it's no surprise. What I was surprised is to find an individual lawyer would have such power over a constitutional provision of advice and consent. Overall, when all was said and done, after the denials from the White House of certain records, after the claims of executive privilege, after Bill Burke went through and screened what he considered to be appropriate and inappropriate documents for the American people to see, less than 10% of Judge Kavanaugh's White House record has been disclosed. Those documents are going to come out someday. And those who are quickly voting for him now without reading them run the risk that they're making a mistake, which they're going to have to explain at a later time. Just yesterday, we learned from a FOIA lawsuit that the National Archives has hundreds of documents concerning Brett Kavanaugh's work in the White House on warrantless surveillance programs. We won't see those documents before tomorrow's vote. The White House apparently fears their contents and prefers to plow through. Why has so much of Judge Kavanaugh's record been concealed? Most likely because these documents contradict what he has said. We've seen a pattern with Judge Kavanaugh from his Senate testimony in 2004, 2006, and again last month. When he's asked about controversial issues that he's been involved in the past, he tries to deny or downplay them. He's done this repeatedly when testifying about matters he worked on at the White House, including the rules governing detention of combatants, warrantless surveillance, controversial judicial nominations like Pryor, Pickering, and Haynes, communicating with the press during the Starr investigation, and his work with Manny Miranda, a Republican Senate staffer who stole documents from Democratic senators' computers, including my own, and shared them with Brett Kavanaugh when he was working in the White House. On each issue, we've seen documents or reports showing that Judge Kavanaugh had far more involvement than his testimony let on. On issue after issue, Judge Kavanaugh's sworn testimony was either misleading or false. This is a judge who claims that words matter. He says he's a strict textualist who holds other people accountable for their words. But when it comes to his own words, he's happy to take liberties and refuse to take responsibility. We've been forewarned of what we can expect if he's given a lifetime appointment on the court. We saw this pattern again last week when he was asked questions about his high school yearbook and excessive drinking. They were legitimate questions that were relevant to the sexual assault allegations at hand. Many of Kavanaugh's answers to these questions simply weren't credible. His explanation of things he wrote in the yearbook didn't pass the laugh test. And multiple people who knew him and socialized with him quickly, publicly rebutted his denial that he ever drank, in their words, quote, to the point that it would be impossible for him to state with any degree of certainty that he remembered everything that he did. I was particularly struck when Senator Amy Klobuchar of Minnesota explained that she understands alcohol abuse because her father was an alcoholic, and then asked Judge Kavanaugh if he'd ever blacked out. Instead of responding, Kavanaugh said, "Have you?" Conservative columnist Jennifer Rubin has written, "It was a moment of singular cruelty and disrespect." It's been hard to take Judge Kavanaugh's testimony at his word on matters both large and small. That matters a lot when we're talking about a nominee's judgment, temperament, and integrity. Judge Kavanaugh's judicial record and his academic writings raise even more concerns. Not only did he check the box on President Trump's litmus test of opposition to the Affordable Care Act and Roe v. Wade, his judicial opinions consistently find ways to favor big business and undermine protection for workers, consumers, women, and the environment. He claims to be a textualist, but he has a habit of creatively defining words. The agri-processors case, which I asked him about directly at the hearing, his dissent abandoned the text of a controlling statute. Instead, he borrowed a definition from another statute in order to argue against the right of slaughterhouse workers to vote to form a union. When I asked Judge Kavanaugh whether he ever worked in a job himself that was dirty and dangerous as a slaughterhouse, he told me he used to cut grass and worked one summer in construction. Or look at his dissents in White Stallion and Mingo Logan cases, where the judge gave his own definitions to key terms in the Clean Air and Clean Water Act. So much for stare decisis. Judge Kavanaugh claims he follows precedent, but we've seen in case after case he goes his own way. Look at his interpretation of the Supreme Court's 2008 Heller decision. Judge Kavanaugh believes the Supreme Court created a history and tradition test for considering challenges to gun safety laws. This test would have courts ignore the public safety impact of gun laws. Judge Kavanaugh admitted that he's, quote, a lonely voice in reading Heller that way. His approach would put at risk many common sense laws, such as keeping guns out of the hands of domestic abusers. Judge Kavanaugh is not a lonely voice on gun safety. He's an extreme and frightening voice on gun safety. After he wrote a dissent laying out his interpretation of the Heller precedent, a majority panel of D.C. Circuit judges, all of them Republican appointees, said this of his interpretation, quote, unlike our dissenting colleagues, we read Heller straightforwardly. Judge Kavanaugh's reading of Heller may be music to the ears of the gun lobby, but it's manipulating precedent, nothing else. Judge Kavanaugh's claim that he follows precedent is also contradicted by his view of the Supreme Court decision in Morrison versus Olson. Rather than admit the majority's decision in the case still holds, Judge Kavanaugh clings to Justice Scalia's dissent, which lays out the so-called unitary executive theory of presidential power. Judge Kavanaugh has been explicit. He'd overturn Morrison. So let's be clear. While Judge Kavanaugh may claim that he'll scrupulously follow precedent, he's shown he's willing to overturn it when it suits him. I've cited just a few examples. The one that's particularly troubling is this judge's view of presidential power. Judge Kavanaugh wrote a striking passage in the Seven Sky decision, dissenting from majorities upholding the Affordable Care Act. He wrote, and I quote, under the Constitution, the president may decline to enforce a statute that regulates private individuals when the president deems the statute unconstitutional, even if a court has held or would hold the statute constitutional. This is a truly breathtaking claim of presidential power, a claim particularly problematic at this moment in history. And then there's Judge Kavanaugh's evolving view on investigations of sitting presidents. When he was working for Ken Starr and investigating President Clinton, he was pretty ferocious. In 2008, he gave a speech and said that he argued now that sitting presidents should be immunized from criminal investigation and civil suit. This was after Judge Kavanaugh spent a period of time working in the Bush White House. He claims he has an open mind on the constitutionality of criminal investigations of sitting presidents. But consider what he wrote in that law review article in the Minnesota Law Review. I quote, if the president does something dastardly, the impeachment process is available. No single prosecutor, judge, or jury should be able to accomplish what the Constitution assigns to Congress. These are not the words of a judge with an open mind. And it was a telling moment when Judge Kavanaugh would not answer at his hearing whether he believed a president should comply with a grand jury subpoena. Here's the reality. We have to consider why this president chose this Supreme Court nominee at this moment in history when the Mueller investigation is closing in. Judge Kavanaugh himself said just a few weeks ago, and I quote, "The Supreme Court must never be viewed as a partisan institution." But the testimony and demeanor of Judge Kavanaugh last Thursday belies any claim he makes of nonpartisanship. I can understand emotion and indignation from Judge Kavanaugh when one considers the gravity of the charges against him and the pain he and his family must feel. But there was fire in his eyes when he read the words he assured us he had personally written. Benjamin Wittes has been a colleague of Brett Kavanaugh. He's published his writings, and he even lent his name as a character reference for the judge. He called Judge Kavanaugh's performance before the Senate Judiciary Committee, and I quote, "a howl of rage." Wittes went on to describe Kavanaugh's partisanship as, quote, "raw, undisguised, naked, and conspiratorial." Charlie Sykes, a conservative commentator, said of Kavanaugh's statement before the committee last Thursday, quote, "even if you support Brett Kavanaugh, that was as breathtaking as an abandonment of any pretense of having a judicial temperament." Judge Kavanaugh abandoned any veneer of neutrality last week before our committee. Out of one side of his mouth, he claimed that he bore no ill will toward Dr. Ford. Then he called her allegations, quote, "a calculated, orchestrated political hit," citing a pinup anchor about President Trump and the 2016 election and revenge on behalf of the Clintons. He even threatened the Democrats, and I quote, when he said, "what goes around comes around." In my 20 years on the Judiciary Committee, I've never heard anything like that, or even close to that, from a judicial nominee. It's hard to imagine how a nominee who has displayed such raw partisanship could then claim to serve as a neutral umpire in the Supreme Court. Judge Kavanaugh, through his testimony, has called his own impartiality into serious doubt. Retired Supreme Court Justice John Paul Stevens, a man who is respected for his integrity and service to this nation, said this week that the performance by Judge Kavanaugh shows he should not serve on the Supreme Court. I agree. At a time when our president plumbs the depths of bad behavior on a daily basis, we should not allow the highest court in our land to now sink to that same standard in their ranks. From a broader perspective, let's be clear what's at stake in this decision. We're in a moment in American history where our system of checks and balances is being profoundly tested. We have a president who has shown disrespect for the rule of law and the role of an independent judiciary. It's likely the Supreme Court will soon consider fundamental questions about presidential authority and accountability. With so much at stake, we should not confirm a nominee to the court unless we are sure of that nominee's credibility, integrity, independence, and judgment. Serious questions have been raised about Brett Kavanaugh. Dr. Ford's testimony was serious and credible. When I asked her directly, what degree of certainty do you have that Brett Kavanaugh was your attacker, Dr. Ford answered without hesitation, 100%. I believe her. Judge Kavanaugh's testimony was simply not credible. From his contrived explanations of his embarrassing yearbook entries to his "I love beer" declarations, he was a sharp contrast to Dr. Ford's measured accounting of a horrible day in her life she cannot forget. I had hoped the FBI would be able to provide us with information to resolve unanswered questions, but they can't do their job if their hands are tied. And when the Republicans in the committee and the White House decided to limit the number of witnesses, unfortunately the investigation could not be completed to meet professional standards. I'll say this to my colleagues. We have to think about what it would mean if Judge Kavanaugh were to be confirmed to the Supreme Court with credible sexual assault allegations against him. Specifically, what it would mean to the millions of women across America who were survivors of sexual assault, women who've been scared to come forward with their stories for fear they'd be mocked, ridiculed, and shunned. What would it mean for them to see Brett Kavanaugh sitting on that bench in that court across the street, day after day, for decades, casting what may be the deciding vote on cases that profoundly affect their rights? It would shake the confidence of millions of Americans in the integrity of our Supreme Court. We should not take that risk. There are other qualified lawyers besides Brett Kavanaugh who could be nominated to fill this vacancy. Nominees whose legal views I may not agree with, but who do not have serious questions about their fitness for office. If there are serious questions about a nominee's temperament, credibility, or judgment, as there clearly are for Judge Brett Kavanaugh, we owe a duty of caution. We should give the benefit of the doubt and protect the integrity of the Supreme Court. With so much at stake, we should not confirm a nominee to the court unless we are sure that the nominee's qualifications are beyond question. I do not have that confidence in Brett Kavanaugh. I will vote no on his nomination.
Mr. President.
The senator from North Carolina.
Thank you, Mr. President. Mr. President, I want to come in and kind of summarize. You and I both, the presiding officer, have had a front row seat in this process. We both serve on the Judiciary Committee, and I think that oftentimes people come to the floor and they want to just give the American public a little slice of what's going on that benefits their narrative rather than stepping back and thinking about what's happened since early July when Judge Kavanaugh was nominated to be on the Supreme Court. That happened on July 9th. Before July 9th, there were many people on the other side of the aisle that had already announced their opposition not to Judge Kavanaugh, but to anyone that President Trump would nominate. We know who they are. They're very well publicized, and I understand that. As a member of the Democratic Conference, I would deny them their right to do that. They oppose the President and anything that he stands for. But then on July 10th, there was a press conference, now that we knew who the nominee was, that a majority of the members also said they opposed him. As a matter of fact, the minority leader said he would fight the nomination with everything he has, and he has. But there's some pieces to the mechanics that I think are important for people to understand. Briefly after Judge Kavanaugh was nominated, the chair and the ranking member got together, and they tried to come up with a framework for releasing as many documents as possible. In fact, that went on for 2 or 3 weeks. In fact, the documents that some of my colleagues on the other side of the aisle said that the Republicans refused to produce were going to be made available on a very focused basis, but with what they call search terms, the way to get into those 100,000 secret documents that they're talking about. We estimate that if our colleagues on the other side of the aisle would have done what they have traditionally done, is come up with agreement on document production, that they would have gained a lot of insights into the documents that we considered relevant, but not necessarily the documents that they would like to use to create another political narrative. But they refused to cooperate, and we moved forward. As a matter of fact, we moved forward and provided more documents for this Supreme Court nominee than the total number of documents provided for all in total of the last 3 or 4 Supreme Court nominees. We also went on to question, or send, I call it questions for the record. What that means is any member on the committee is entitled to compel the nominee to answer questions after the hearing. Judge Kavanaugh was subjected to over 1,200 questions for the record, under oath, that he had to submit back to the committee members. Those questions for the record are a multiple of any one nominee in the past. In fact, I understand it's probably the sum total of questions for the record that all the nominees on the bench were subjected to. So the questions were asked, the documents were presented. All that document production was going on in the latter part of July and August. The first tranche of documents came in about the second week of August. But what else was going on in the latter part of July and August? A letter which was first submitted to a congresswoman from California was then routed to the ranking member and the senior senator from California. In the end of July, a document that was expected to be held in confidence, a document that we now know was authored by Dr. Ford, provided to the Judiciary Committee with the understanding that her name would not become public. Now, in the past, the chair and the ranking member have a great relationship. They have a trusting relationship. In the past, when you had something that you thought was material to the consideration of a nominee, a ranking member and a chair would try to figure out how to actually assess that information to treat the person in question, in this case Dr. Ford, fairly and to hold her information in confidence. That didn't happen here. Actually, there was no communication with the chair by the ranking member. A few weeks into it, we do know that there was some consultation from what Dr. Ford says was a committee staffer to retain an attorney who has a very well-publicized reputation for being partisan. I don't have any problem with that because we've got partisan attorneys on both sides of the aisle. But at the recommendation of a committee staff, which is what Dr. Ford said under oath, they retain an attorney who's working pro bono. Now, I'm really wondering whether or not some, not all, but some of the people on the other side of the aisle genuinely cared about what I believe is a traumatic experience in Dr. Ford's life, genuinely care at trying to go through a process that would provide Dr. Ford with some closure. Because if they had, maybe they would have gotten to someone who could interview her in the way that people experienced with sex crimes interview persons who have experienced a traumatic event. These attorneys who were retained didn't do that. Maybe when the attorneys that she retained, who are pro bono attorneys, that means they're not being paid, they're doing it at no cost, or at least no cost to Dr. Ford. Maybe if the attorneys really cared about Dr. Ford versus the outcome, maybe they should have recommended to Dr. Ford to have the hearing. But that didn't happen either. Now we move further through, and after the hearing, or at the hearing, we have 32 hours of hearings. The letter was known to the ranking member. I don't believe it was known to any other member on the committee. 32 hours of hearings. Each one of us had 2 rounds, virtually an hour to ask questions of Judge Kavanaugh. Not even an abstracted series of questions protecting the identity of Dr. Ford, but questions that could have potentially raised the issues that we now saw after the hearing. 32 hours of hearings, nothing mentioned. An hour and a half private hearing that, unfortunately, Senator Feinstein, for whatever reason, wasn't able to attend, never brought up. After the hearing, then we hear about these allegations. Now, I've had some people on the other side of the aisle say that we rushed the committee process. The fact of the matter is it was delayed for 2 weeks after we found out about the allegation. 1 week was to get to a point to where we could accommodate Dr. Ford and have her come and testify before the committee. Chair Grassley was criticized by some of the folks on my side of the aisle because he said he shouldn't be accommodating, delaying, set a deadline, move forward. He didn't. He spent the weekend trying to figure out a setting, a method that Dr. Ford would be comfortable with. But let me back up a week earlier. A week earlier, the chairman and the committee offered to Dr. Ford to go to California to interview her outside of the lights, outside of the circus that sometimes occurs here, but to interview her and to have the attorneys present during the interview. In the hearing that we had with Dr. Ford, the question was asked, were you aware that the committee offered to come to California in a confidential setting, allow you to do your testimony? Her response to that question was, I did not understand that. So that really raises a lot of doubts in my mind about either the competence or the agenda of her counsel. So now, at this point, I believe that there are 2 sets of people who are opposing Judge Kavanaugh's nomination. There are some that just genuinely disagree with his judicial philosophy. I actually have voted for some judges. I disagreed with their judicial philosophy. There are some on the agenda that I will again, but I'm going to vote for them, and I'm going to get criticized from people on the right side of the aisle because they're considered unanimously well qualified And just because I don't like the way I think they may rule in certain cases, that's not enough for me to vote against them. But maybe for other people on the other side of the aisle there is. Then there's another group of people over there who I genuinely believe have used witnesses, have used this process to just advance a political message and a political agenda. The last thing, another reason why I believe that is how the narrative changes depending upon what sticks. Now, we've received the additional background investigation. I should mention, Judge Kavanaugh's had 7 background investigations over the last 25 years. I saw a stack of documents in a secure facility that's about that thick. I would estimate 600 to 1,000 pages of prior federal FBI background investigations to clear him for other roles that he's had, and 2 in this case. Over 25 years, talking to 150 people, some as recently as about 10 years or less than 10 years after he was in college, not a whiff of any of the allegations that we've seen put forward, not a single note. So, as more information comes up, you see the narrative going from the weight of the allegations, because honestly, in every instance where an accuser has made an allegation and said these people were present, those people have been identified or have been interviewed if they were willing to. None of them have corroborated the allegations that were made. None. And in the follow-up investigation, it even further undermined the sort of inference you draw when somebody says, yeah, these people were here, check with them. We went back and checked with them, and it further undermined the veracity of the allegations that they were made. So now it looks like the narrative on the allegations is beginning to wane. So now the new narrative, and Mr. President, this is the last I'll be talking about, the new narrative is that, well, even if the allegations are untrue, the way that Judge Kavanaugh behaved in the hearing that he came before, he was angry, raises a question about his judicial temperament. Well, ladies and gentlemen, first, the American Bar Association has voted Judge Kavanaugh unanimously well qualified twice. And at least the most recent rating, they even spoke specifically to his temperament on the bench. And I saw his temperament during the hearing, 32 hours. He sat in that chair in some cases for 2 or 3 hours without getting up and was patient when some unfair questions were being asked. He was cut off repeatedly. He maintained his composure, and he did well in about 31, 32 hours of testimony. Last week, I didn't see Judge Kavanaugh in the hearing. I saw Brett Kavanaugh. I saw a father. I saw a husband. I saw a son who was defending his honor. I saw somebody dragged through the mud without a single allegation, with any corroborating testimony, defending himself as a human being. And he did well for about 2 hours. And on a final note, I firmly believe that Judge Kavanaugh is going to go to the bench, and I firmly believe, because of his independence, he's going to take some rulings that I'm not going to like, but he's going to do it for the right reasons. And what he's going to say is, instead of treating us like a non-member legislature, go do your job, Congress. Change the law if you want me to have a different opinion when it comes to the court. We should be now, in that light, thinking about how we work together on a bipartisan basis to change things that we don't like, not expect a non-member legislature to do our job. So, Mr. President, this has been a very difficult process. I know it's been extraordinarily difficult for the Kavanaugh family and for Dr. Ford. I pray for Dr. Ford's peace. I hope that she finds closure. I hope that there is some way that she will be able to re-examine the facts of that summer in 1982 or 1983 and identify precisely what happened, precisely who can corroborate it, and have someone held accountable for that act. But I don't believe by any stretch of the imagination, based on the information presented to us, that's Judge Brett Kavanaugh. And for that reason, I'll be voting no tomorrow. Or I will not be voting no tomorrow. I'll be voting yes tomorrow. Thank you, Mr. President. I yield the floor.
The Senator from Oregon.
Mr. President, the deeply misguided vote to move forward on Brett Kavanaugh's nomination has taken this Senate one step closer to a moment that will cause enormous pain for millions of Americans, particularly women and survivors of assault. Now, some may say that the Senate is rolling back the clock on women in America by confirming Brett Kavanaugh. After seeing what's happened to the women who've spoken out and talking to women in Oregon, I question how much the clock ever ticked forward. Indeed, this process has shone a spotlight on the double standard that women across this country face, just so that they will be believed. On the other hand, Dr. Ford never wanted any of this. The way she has been treated by Republicans in this Senate and the President of the United States is inexcusable. In one of the most unpresidential speeches I've ever seen or heard, the President belittled a survivor in front of a crowd of thousands. Mr. President, Dr. Ford came to us as a citizen who was doing her civic duty to provide the Senate with crucial information about a nominee before us. She called the front desk of her congressperson. She didn't run to the news media or the cable shows or try to sell a book. She volunteered to tell her story under oath. She recounted the details of her assault in 18 minutes of testimony that will not soon be forgotten. It was heartbreaking to watch. At times, it was just excruciating. What did Dr. Ford get for her courage? She was put on trial by the Republicans on the Judiciary Committee, who actually hired an experienced prosecutor to grill her. The questioning was clearly designed to tar Dr. Ford as a political pawn. It attempted to delegitimize the trauma caused by her assault. It attempted to paint her as a liar. It was stunning how little of the questioning Republicans subjected her to was focused on what Brett Kavanaugh did on the night in question. It's clear now that the focus was on undermining Dr. Ford's story and destroying her credibility. But Dr. Ford's credibility held up. I've said I can't imagine a more credible witness, nor can I imagine how difficult it must have been for her to relive that experience and maintain such extraordinary composure. What she did, took unknowable strength. Her testimony, delivered under what amounted to prosecution, was unforgettable. She is trained in psychology. She was even forced to act as the expert witness in her own trial, diagnosing the lifelong effects of her own trauma. She explained to the committee how memories of traumatic events implant themselves on the brain. At one point, she described what she remembered most about the assault by Mr. Kavanaugh and Mark Judge. She answered, delivering on her training, that it was indelible in the hippocampus is the laughter. I believe Dr. Ford when she says she was assaulted in that room in 1982. I believe Dr. Ford when she says her attackers locked the door, a hand was pressed over her mouth, and she feared for her life. I believe her when she says she remembers them laughing. For all the grueling prosecution the Republicans put Dr. Ford through, it's important to compare that to the treatment of Brett Kavanaugh. When it was Kavanaugh's turn to deliver testimony, he was seething. He was raging in a manner completely unbecoming a federal judge. He behaved in a manner that directly contradicted what Brett Kavanaugh said in a widely publicized speech a judge should be all about. In his own words, Mr. Kavanaugh said, judges need to keep their emotions in check, be calm amidst the storm. Mr. Kavanaugh failed his own test last week. He offered the most partisan testimony I can recall when he talked about the Clintons and said, what goes around comes around. Imagine if a female nominee had snapped at a male senator about his drinking habits. The President of the Senate is an experienced judge, prosecutor. I'm telling you, if a female nominee had done that, game over right there. Right there. And there again, you have the double standard. When a few questions posed by the Republican prosecutor actually got to relevant questions, the majority side of the committee told her to just take off. For that to be the only hearing on these allegations, I think is just plain disgraceful. The committee should not have moved on to the vote. The allegations brought forward demanded a robust investigation. Yet the Senate has ended up light years away from that. What kind of investigation looks to settle matters and doesn't interview the accuser and the accused? That just doesn't pass the smell test. This is not about tarnishing Brett Kavanaugh's reputation or digging up salacious details of his high school days. The accusations against Mr. Kavanaugh and the possibility of perjury, both of which he denies, relate directly to his binge drinking and sexual behavior. That's why the FBI background check should have been a robust inquiry into those matters. It's clear now that didn't happen. You ask yourself, why not? It's hard to find an explanation other than the investigation was handcuffed to predetermine the outcome. Dr. Ford has said publicly the FBI didn't talk to her. They didn't look at the therapy notes she offered to turn over. They didn't talk to Mr. Kavanaugh. They didn't talk to the dozens of individuals Deborah Ramirez said could potentially corroborate her story. They closed the investigation a full day ahead of the arbitrary deadline, and it's not clear why. Based on that, in my view, this investigation was a whitewash. It was not legitimate. It was a product of intense political meddling, in my view, by the Trump administration. That means if Brett Kavanaugh's nomination is confirmed, there are going to be questions about his legitimacy looming large for years to come. Mr. President, I believe, Dr. Ford, I heard you discussing this morning on television. I respectfully would say, I know you don't share my view, but I felt that Brett Kavanaugh's behavior before the Senate last week ought to be disqualifying on its own. And if you compare what he said last week to what he wrote, ought to be the requirements for how a judge behaves. There is a very large gap between what Brett Kavanaugh said ought to be expected of a judge's behavior and what we saw last week when he testified. From the time his nomination was announced, Kavanaugh portrayed himself as a trustworthy individual who had the kind of level-headed temperament Americans expect and deserve from members of the judiciary. My view was that appearance last week before the committee my colleague serves on was a textbook case of raw partisanship. In his afternoon testimony last week, Brett Kavanaugh was disdainful and sarcastic of the Democratic senators who questioned him. Brett Kavanaugh responded to what he considered unsubstantiated allegations by making truly unsubstantiated allegations of his own. Without any evidence, he declared the credible accusations that had been brought forward a calculated and orchestrated political hit by the Democrats. He pushed these baseless, conspiratorial comments about how this was all just revenge for the Clintons. And in a tone that just struck me as dripping with menace, he just said, what goes around comes around. And if you look last week at how he presented himself to the President of the Senate's committee, I think you've got to ask yourself, how can anybody expect that Brett Kavanaugh would offer a fair hearing in a politically charged case? So my conclusion, based on what I've described, is pretty simple. You just do not get to behave the way Brett Kavanaugh behaved last week and get to serve on the United States Supreme Court. Finally, Mr. President, my concerns go further than the temper tantrum we saw last week. There is hard evidence that shows that Brett Kavanaugh lied repeatedly and on a variety of subjects. For example, just yesterday, there was new evidence in scores of emails that the nominee lied about his involvement in government wiretapping programs. Now, the President of the Senate has been very gracious over the years in talking to me about these issues. He knows I care deeply as a member of the Senate Intelligence Committee about government wiretapping programs. I'm here this afternoon to say I'm not alone. Millions of Americans care about this issue. As I've said in my conversations with the President of the Senate, security and liberty aren't mutually exclusive. You can have both. But what these emails, scores of them yesterday, prove is that there is new evidence that Brett Kavanaugh did not tell the truth about his involvement in government wiretapping programs. There's hard evidence that showed he lied about using stolen documents. Hard evidence that showed he lied about his involvement in the confirmation process of certain Bush nominees. Hard evidence about the statements made by the other individuals who were present at the party where Dr. Ford was assaulted. Hard evidence the nominee lied about when he learned of the second set of allegations made against him. Nominee even lied about small stuff. When you can't trust somebody to tell the truth, they don't belong on the Supreme Court. Now, it's important, before I wrap this up, Mr. President, take a hard look at what's happened to the court over the last few years. In 2016, Senate Republicans blocked a mainstream nominee to the court, an individual who many Republicans had praised extensively in the past. They held the Supreme Court seat open for nearly a year until a Republican president picked someone to their liking. In 2018, the Trump White House interfered with the vetting of a second nominee, hiding key information from the Senate and the American people. The floor debate on this nomination is going to be cut off before all the questions about sexual misconduct can be answered and before the statements that I have outlined here today, ones where there is hard evidence, can be examined for perjury. These actions by the Republicans and the Trump White House, in my view, are taking a sledgehammer to the public's trust in the court as an institution. The court used to have a healthy separation from the partisan battles that take place here in the Congress. I heard my colleague talking about that this morning on television. That healthy separation doesn't exist today. I just say we've got a lot of heavy lifting to do here in the United States Senate to revive the vision of the Supreme Court held by the Founding Fathers after what has happened. I'm going to close by going back to the question of whether anything has changed since 1991 and the tragedy of Professor Hill. When Professor Hill testified in 1991, she was dragged through the mud. She was called a scorned woman. Perhaps you could say that it represents some measure of progress that Dr. Ford wasn't slandered and insulted in quite the same way. But I don't know how much that matters if this nominee is confirmed. The language used during the debate might sound different, but the outcome's the same. The failure by my colleagues on the other side to step back, suspend the partisan warfare, and recognize the seriousness and legitimacy of this information, in my view, will go down over time as a historic disappointment. This was never a smear campaign. It wasn't a political hit job. Dr. Ford came forward out of a sense of civic duty. She knew the sacrifice she faced, and she wondered to herself if it would really make a difference. Why suffer through annihilation if it won't matter, she asked. Over and over again, she told us she only wanted to be helpful. I've never seen a witness, unlike my colleague presiding today, I've seen a lot of witnesses. Textbook case of being courteous, always saying, what can I do to be helpful? Senators ought to consider the dangerous signal being sent to survivors of assault and to young people across the country from this debate. Dr. Ford wasn't on trial, but nonetheless, she was prosecuted by the majority party. She got smeared as a political pawn, a liar, belittled, with her accusations dismissed by many almost immediately. I made notion of how a few days ago the president mocked Dr. Ford, mocked her in front of thousands. What a cruel and unpresidential moment. The mockery and dismissiveness aren't bad enough. If they weren't bad enough, There's the return of the sickening old notion that boys will be boys, that what happened in the bedroom was roughhousing, and that what happened was just too long ago. Today, survivors from sea to shining sea are asking, how are we going to be heard? How will we find justice? I fear many survivors are going to conclude that coming forward with their story is going to be pointless, and there is very little likelihood of justice. Very little likelihood of justice. Even if you're strong, composed, and constantly courteous, it won't help. On the other hand, the signal to boys is this. Even if you engage in violence against women and lie about your conduct, the power structure is going to step up and protect you. The Senate has to be better than this. I hope senators are going to recognize that it is time to take these horribly outdated attitudes towards women and sweep them out like the cobwebs from an abandoned theater stage and start over. It can begin by rejecting this nomination today. I will be voting no, and I yield the floor.